Good morning and welcome to the Protection of Personal Information Act webinar. My name is Philip Kruger, and just by way of background, I am a legal advisor in the legal department of RSM South Africa, situated here in Johannesburg. And really this morning we're going to be looking at data protection in general, as well as then in particular the Protection of Personal Information Act, or the POPI Act as it's colloquially known. As we know, the POPI Act is very, very topical at the moment. But not everyone knows exactly what is expected, when the Act will be implemented, or what is to be done in terms of implementing the Act. And that's what we're going to be exploring this morning, and we'll try and do that in this presentation under the following headings. Firstly, we're going to look at what it's all about really, and who the role players are. We're going to look at the applicability of that. We're going to look and stand still for a little bit at the 8 processing conditions. And then we're also going to have a look at the scary bit, really, the breaches and damages. And then lastly, I've also included a slide just to have a look at where we are now and what to expect going forward and what we see to be happening going forward. Then without further ado, I think let's start. Firstly, looking at what is POPI really. So the acronym POPI refers to the Protection of Personal Information Act, number 4 of 2013. The Act was signed into law already on 19 November 2013. So that should give you an indication that it's really been a long time coming. It has been well debated and really anticipated within the legal fraternity. The regulations to the Act were only published on 14 December 2018, so they've only been published fairly recently. So that should also give you an indication that there was quite a bit of debate and quite a bit of back and forth in terms of finalizing those regulations. In terms of the implementation date, and I think that's really what all of us are waiting with bated breath for, we are currently awaiting the proclamation of that date. However, I have been in contact with some industry role players, and by all accounts, it seems to be imminent. So we're really expecting it to be within the next couple of months, and we're hoping to get clarity on that quite soon. What is important to know, though, is that in terms of the POPI Act, there is a 1-year transition period. So once we get the date of implementation, the actual enforcement will be 1 year after the implementation date. So you basically have 1 year to really start getting your processes in place to make sure that you are compliant and that you kind of have all of your security measures in place. So really there's not a lot of time to waste in terms of moving forward with this. So looking at the formal definition then of what the POPI Act is it's legislation designed to protect any personal information, and we'll stand still and look at what personal information is during this presentation, which is processed by both private and public bodies. So important there to see that it envisages any private entity, that could be trust, could be a company, could be a CC, whatever form of vehicle that might take, or public bodies, which of course would then include government, as is noted on the slides there. Another definition that really just tells you where it applies. Some exceptions do exist, but every person who collects, stores, and otherwise modifies or uses information is responsible under POPI and must comply with the conditions required for lawful processing of information. The conditions, of course, being the 8 processing conditions that we'll look at this morning. But what is important from both these definitions is that you can see that the application of POPI and really the field where it's envisaged to be applied is as wide as a day is long. It is extremely wide, and if you are doing something with information, it is most likely that it'll apply to you. I think let's move on and look at who the role players are before we delve into the nitty-gritty of it. At the top there, you can see, as expected, there is a data subject, and really all that is the person or entity from whom you collect the data. It's the person to whom that data relates. Right underneath there, we have the responsible party, and that's the person or entity who collects or processes that information. For those of you who are familiar with the GDPR clauses or terms, in GDPR, that would typically be your controller of that information. But what is important to know about the responsible party is that really, when it comes to liability, the buck stops here. This is ultimately the party who will be held responsible in the event of any breaches of data. Right to the side of the responsible party, you will see there the information officer. Now, the information officer is really the individual within the responsible party who will be heading all of this up. It serves to be noted at the outset that this role can be outsourced. It is possible to outsource it. And in fact, there are service providers at the moment that do provide that sort of function. Generally, the Act describes it as being the head of a private body. And when we're speaking about the head of a private body, ultimately we're saying it's the CEO or the MD, but we all know that their plates are very full. It's not always possible to take on an onerous task such as this one. So the Act also does allow for this function to be delegated. And usually in consultation with clients, what you find is if you say that this function can be delegated, the clients get a kind of a glint in the eye, and they think, well, we can delegate it to kind of a very junior person. And I'm afraid, even though that the function can be delegated, that is not what's envisaged by the Act. The information officer is really supposed to be someone who can firstly enforce policy, and secondly, someone who can influence decision-making and the creation and establishment of policy. So even though it certainly doesn't have to be the head of the private body, it has to be someone senior enough to make sure that policy can be enforced, can be implemented, and in truth really can be created as well. Then looking at the data processor, really that is a term that the Act has established to describe a third-party processor. So really that would refer to your cloud providers or anyone that would be processing personal information of a data subject on mandate of the responsible party. What is very important is that Section 20 of the Act is applicable here, and that determines that it has to be a written mandate in terms of which this company or individual would be processing the information. They have to have proper and adequate security measures in place. And very important, as we mentioned earlier, the buck still stops with the responsible party. So even though you've outsourced the processing of that information and it sits with the data processor, in law, ultimately, the responsible party will still be held liable if there is a breach. So as any good lawyer would tell you, where you have someone else doing something on your behalf, but you are still really responsible for what they're doing, ultimately, when you look at contracts with cloud providers and with any third parties who will act as data processors on your behalf, you should be looking at your contracts and making sure that you have proper indemnities in place to really deal with that sort of liability. Then we also have the regulator, lastly there. Ultimately, the regulator will be the enforcer of the POPI Act. The regulator was appointed on 1 December 2016 already. It is a very capable individual called Advocate Panzi Tlakula. She has ultimately been appointed. She also has been appointing the members of her team, and so far everything seems to be on track, even though they're not fully operational just yet. It does serve to be noted that I was informed yesterday at a seminar I was attending that they have received up to 300 complaints already. So even though they're not fully operational yet, there are already complaints being received and in fact dealt with. What they have indicated is that the regulator will have a very strict policy view, a very strict enforcement view, and a very pro-human rights view. So that is quite handy just to bear in mind when creating an expectation in terms of what to expect from the regulator. Then looking at what personal information is, as promised. So personal information really refers to information of any identifiable living natural person or an existing heuristic person, as far as it may be applicable. And that second one is actually quite interesting, because that is not something that you would find, for instance, in the GDPR. And really, it's very few jurisdictions out there that include heuristic persons under the protection or data privacy protection. First one on the definitions there is it refers to anything that relates to a person's race, gender, sex, pregnancy, marital status, national or ethnic, social origin, color, sexual orientation, age, physical and mental health, well-being, disability, religion, conscious belief, culture, birth. And a lot of these fields that's listed in this part of the definition really refers to what's called special personal information. Just standing still at special personal information, that is information that has an even higher threshold than general personal information in order to process that. In fact, the Act creates what's called a general prohibition on the processing of special personal information. However, in Section 27 of the Act, you will find that there is a general opportunity to process special personal information if you have certain forms of lawful reason for processing it. And those forms of lawful reason would firstly be found in the consent of the data subject. Secondly, if there would be an obligation in terms of law or international law to process such information, or if the processing of the special personal information is for historical, statistical, or research purposes. And there should also then be substantial public interest in that type of historical, statistical, or research purpose. And then the last two there, if the information has in fact been made public by the data subject himself, he can't rely on that information. And then also, if you do process special personal information, it's very important to comply with sections 28 to 30 of the Act, which will tell you exactly what you need to do in the event that you process information such as that. Then secondly, it refers to education, medical, financial, criminal, and employment history. Important there to note also that criminal history is also a special personal information field. Employment history is quite an interesting one, particularly if you think of it in practical terms. We all receive CVs, which set out employment history in great detail. And it really, POPI really drills down to things as simple as that. A CV would contain some fairly substantial personal information and should be dealt with in terms of the POPI Act, and that information should really be safeguarded. So we all generally send on CVs to colleagues to have a look at, etc., etc. So it's very important to make sure that you have the consent to really release that information. Any identifying number, symbol, email address, etc., etc. Important on this definition, you can see a lot of fields are included there: physical address, telephone number, location information. And all of these could also link together to create personal information. Really, if you think about a general email signature, it will have your telephone number, it will have your email address, it will have your physical address, it will have your name, it will have your designation, the position that you have in a company. So really, personal information goes a lot further than one might initially think that it does. Continuing further, and this is quite an interesting one, biometric information. Biometric information will also be special personal information. Biometric is defined in terms of the Act, and it's defined to say it's a technique of personal identification based on physical, psychological, behavioral, and other characteristics, and it includes things like blood typing, fingerprinting, DNA, and voice recognition. So it all sounds very far removed from what most companies would deal with on a daily basis, unless you are in the healthcare sector or the like. However, certain experts and certain academia have seemed to argue that biometric information would also include photographs, because photographs hasn't been put in any other sector yet, and they argue that it may well be included here. And you very often find that people process photographs of certain individuals, and that would then in fact be special personal information. Further on, personal opinions, views, or preferences. The views or opinions of another individual about a specific person. Correspondence sent by a person that is implicitly or explicitly of a private or confidential nature. And then the name of a person if it appears with other personal information relating to that person, or if the disclosure of the name itself would reveal information about that person. And that refers back to that slide where we referred to linking, particularly then things like your physical address, identity numbers, email addresses linked with a name could be considered to be personal information. Moving on to our next slide, as you can see, the definition of personal information is extremely wide. It literally includes almost everything under the sun. So let's look at what processed means in terms of the Act. So processing literally could be any activity concerning personal information. There are some examples from the Act. For example, the collection, receipt, recording, organization, collation, storage, updating or modification, retrieval, alteration, consultation or use of that personal information. The dissemination by means of transmission, distribution, or making available in any other form. So typically where you would be distributing that information then to others as well. And any merging, linking, restriction, degradation, erasure, or destruction of personal information. So even destroying personal information is deemed to be processing. So as you can see, that is very, very wide. And really, if you are dealing with any form of personal information, you are processing. So having seen how wide the ambit of POPI really is, it really is one of those things where it might be easier to say, when does POPI not apply? And the Act has included a number of instances where it doesn't apply. The first there would be for purely household or personal activities. Interestingly enough, the regulator unfortunately wasn't, or the legislator unfortunately wasn't kind enough to include a definition of what is purely household or personal activities. But I think we can basically, we can quite firmly assume that it would be activities regarding your family, your household, your personal processing. When it comes to processing individuals that might be performing work in your household, that I think, in my view, might be excluded, because that drills down to more of an employment relationship than a personal household or personal activity. Then secondly, any information that has been de-identified. In terms of the de-identification of information, it's very important that it's completely de-identified. So in other words, the information must be anonymous to such a degree that it cannot be re-engineered to identify specific parties. Then any information that is processed on behalf of a public body in the event of national security, defense or public safety, prevention, investigation, or proof of offenses, or prosecution or the execution of sentences would not be subject to POPI. And I think it's fairly evident why not. Those are instances where there would be a greater public interest in having that information processed. And then lastly, processing for purely journalistic purposes that must be subject to a code of ethics that provide for adequate safeguards and protection. So in other words, not saying that that personal information doesn't deserve a protection, it's just saying that there already is a code of ethics that provides adequate safeguards for protection. But as you can see from this list, even though it does tell you when POPI doesn't apply, it's quite a limited list. And especially for corporates or businesses, I think it's safe to assume that most of your processing of personal information will fall squarely within the ambit of POPI. In terms of our next slide here, we're going to be looking at when you can process personal information. What is also very important to note about consent is the fact that consent has to be informed consent. And in a South African context, that is actually very, very difficult, because if you think about it, we have language barriers, we have education barriers, we have socio-economic issues. So what is considered to be informed consent for a very educated, very sort of sophisticated individual might not be true for another individual. And in a country with 11 official languages, the question of whether your consent was fully understood and rationally consented to becomes a very difficult question to answer. So a lot to be aware of in terms of consent. Then secondly, if it is necessary for the conclusion or performance of a contract to which the data subject is a party. So there, my typical example is usually an employment relationship. By virtue of the nature of concluding an agreement with an employee, it means that it's going to be necessary to process their personal information. Then an obligation imposed by law on the responsible party, and that's important to note. So quite often you get the question asked, what about FICA? What about the Companies Act requirements that says you have to keep certain information for 7 years relating to directors? Where there is an obligation imposed by law, that obligation will always have preference. Then they also to protect the legitimate interest of a data subject. So that would typically be in the event of a health emergency, for instance. If you literally cannot consent to your personal information being processed, surely it's in your legitimate interest to get help as soon as possible. So typically that would be an example of that. Then also where it is necessary for the proper performance of a public law duty by a public body, or where it's necessary to pursue the legitimate interests of the responsible party or an interest of a third party to whom the information is supplied. So there, a typical example would be taking your information when you enter a building or an office space. Quite often you find these days that you have to enter your details on an iPad when you enter an office space. And that would then typically be that responsible party saying, I'm processing your information under a lawful purpose because I have an obligation or a legitimate interest to make sure that I know who's in my building and what is going on there. Or for instance, if there's an accident in the parking lot, that you can actually follow up and provide those details. What is important to note is that under all these cases, once you have lawful permission to process personal information, you therefore have to process that information under the POPI Act, which means you have to comply with the 8 processing principles in terms of POPI when you process this information. So lastly, very important to note, the responsible party bears the burden of proof to prove that he had this one of the grounds listed above to process the information. So what are the 8 processing conditions imposed by POPI? I'm going to run through them fairly quickly, but I will give you a little bit of detail on each of them. Firstly, accountability, and basically that any good lawyer will tell you when you read the word accountability, it equals the word liability. So really this is the kicker. This is the one that places you squarely within the processes of the Act. It means you have to be accountable to comply with the 8 principles that will follow. Processing limitation, data should only be obtained by limited and lawful processing that does not unnecessarily infringe in privacy. And really this strikes towards the concept of minimality. Processing shouldn't be excessive for the purpose of the reason why the data is collected. So in other words, you have to make sure that you have a lawful consent. You have to make sure that if you are relying on consent, that it was informed, and you do not have excessive measures of actually processing the information for the purposes that it was collected. Purpose specification, again, you have to make sure that the purpose is stated for why, or the reason why, the motivation why you need the information is stated in whatever consent you are obtaining, and that that reason has to be specific, explicitly defined, and lawful. Further processing limitation. This is typically where a company would collect information for a specific purpose and then keep that information for further processing. However, that further processing is limited to the original purpose for which that information was collected. So in other words, if I saw a client and I received a consent to send him further information for legal matters or for matters in the financial and legal field, I can't suddenly be sending him information that relates to a friend's car wash service, for instance. So just to make sure that you do not exceed the original intention of the purpose of the collection of information, further processing would have to be in line with that. Further processing limitation also brings into play your retention policies. It is so that POPI states that you have to destroy personal information once you do not need it anymore. And it literally means destroying it. The safest thing would probably be to put it through a shredder. But the truth is, we would all have to start keeping very detailed retention schedules, because in an average day, we receive so much information that if we don't detail an account for when we received information and why we received this information, it's almost going to be impossible to comply with retaining that information for only as long as is necessary. Further then, information quality is our next processing consideration there. And that really means that we have to take reasonable and practical steps to ensure that the personal information is complete, it's not misleading, and it's accurate, and then importantly that it's updated. The onus or the burden of updating the personal information lies with the responsible party and not with the data subject. Openness, this refers to notifying the regulator if it requires a pre-approval. And there are certain fields of personal information that may require the pre-approval of the regulator before it's processed. But importantly, it also refers to your processes. What happens if there is a breach? You have to notify the data subject. You have to notify the regulator. And importantly, the notification to the data subject has to be in writing, and it has to contain certain information. It has to tell the data subject what the possible consequences could be of that breach. It has to tell the data subject what possible steps they can take to mitigate any damage to them, and what steps you have indeed taken to mitigate any damage to them. And also importantly, that notification to both the regulator and the data subject has to be sent within reasonable time after you have come to know of the breach. So there can't be any undue delays there. Security safeguards, I think this is the one we are all quite sure of. We all know that we have to implement IT measures and quite stringent IT security safeguards in order to protect personal information that we keep on our servers. But what is important is that those security measures must always be adequate and appropriate. So it doesn't necessarily have to be excessive. It doesn't have to be Fort Knox, but it has to be able to keep that information safe. Data subject participation, a very important one there. It really is for the data subject to be able to access the information, to be able to update the information, to make sure that they are happy with what you are retaining. But importantly, it also implies that the data subject can object to the processing of the information of any time, that they can withdraw their consent at any time, and that they have the right to be forgotten. So the right to be forgotten means they have the right to request the deletion of the information. But what is important is that the right to be forgotten is not an absolute right. It may be subject to limitations. So in other words, where there is an obligation on the responsible party to keep that information, so if it would be criminal information, for instance, or if it would be information that you are required to keep for FICA purposes, they cannot insist that you delete that information prior to when the law actually states that you can delete that information. So very important, it's not an absolute right. Coming now to breaches and non-compliance. In the event of a breach, any person may lodge a complaint with the regulator. And important to note there, it's not just the data subject. Any person with knowledge of the breach can lodge a complaint with the regulator. The regulator will then typically try and secure a settlement between the parties, and there will be certain pre-investigation activities that will go on in terms of trying to secure that settlement. If no settlement is possible, then the regulator will initiate a formal investigation. Very important to note there that the regulator has quite extensive powers. In terms of initiating an investigation, they may call witnesses, they can interview any person that they would wish to, they can administer the oath to witnesses, and then also very important, they have search and seizure powers in terms of the investigation. They can enter your premises if a proper warrant is obtained, and they can seize certain assets if they need to examine them further to properly do an investigation. If it is found that there was in fact a breach, the regulator may enforce an enforcement notice, or issue an enforcement notice rather, and the data subject or the regulator or both may sue the responsible party for damages. And what is quite scary for particularly a lawyer reading the Act is that the Act implements what's called strict liability. And that really means that the data subject does not have to prove what's called intent or negligence. The fact that there was a breach will be enough. You don't have to prove that the responsible party was negligent to be successful in the claim. Then looking at what the potential damages could be. At this point, it's uncertain what amounts would be awarded, but we have seen internationally that it's been substantial fines, particularly under the GDPR. We've seen some massive fines coming out. But what is clear and what is defined by POPI is that it could be damages for both patrimonial and non-patrimonial loss. There can be aggravated damages. There can be interest charged on whatever the damages award will be, and of course legal fees. The Act also then imports what's called to be guilty of an offence. Now really that means to have contravened some form of process in terms of the Act. And it would look at particularly sections 100 to 106, and it's any person who hinders or obstructs or unlawfully influences the regulator when a responsible party fails to comply with an enforcement notice, offences by witnesses, for example, lying under oath, and unlawful acts by responsible parties in connection with account numbers, or unlawful acts by third parties in connection with account numbers. What is very important, however, is to note that if you are found guilty of an offence, the penalties are quite stringent. It's 12 months or 10 years imprisonment, or 12 months to 10 years imprisonment, or a fine of up to 10 million rand, or both. So as you can see, it's actually quite stringent penalties implied there. But really, in terms of POPI, what I can't stress enough is that you would also suffer reputational damages. If you think of companies such as Ashley Madison, who had the big data leak scandal, the Facebook scandal that we all know of, Liberty had a big data breach, and in this week, in fact, Eskom. I think we do need to realize and understand we live in a digital age where you have to ask yourself the question, would you trust or provide business to a company that cannot guarantee the safety of your information? And if that answer is no, we have to realize why POPI is so important. What is also very important to realize is that it's not always a breach from the outside that you need to fear. Everybody seems to think you need to think about hacking and cracking and all of those types of things, which is important. I mean, you get ransomware and all of those things do happen. Companies are held ransom for their personal information by external third parties. But more often than not, a breach will actually happen without any malicious intent. It might happen internally. It might be one of your employees who releases information without thinking or without knowing. So training of employees is absolutely essential. And particularly where an individual has had many roles within the organization, it's quite important to revoke the authorities, where he moves from one department to another, quite often you'll find that those authorities are not revoked, and you sit with an individual that really has access to much more personal information than he would necessarily or reasonably need to have. And that's typically where the danger lies in terms of an internal breach. We are reaching the end, and I know we are slightly over time. I am just going to run through this last slide quickly because I do think it is important. So if you can stay for it, please do. Firstly, I would like to just look at where we are now and what to expect, and then particularly the regulations that have been published recently. To be quite honest, having read through the regulations, I did not receive as much clarity and interpretational guidance as I had hoped to see in the regulations. Really, only a small portion of it relates to the content of POPI. Particularly, there are some helpful provisions in terms of the information officer in the regulations, but not really much to further the understanding or content of the Act. What is very helpful in terms of the regulations is that all of your forms have been published in there. So, for instance, your consent forms, your consent withdrawal forms, your notification forms, etc., all of those examples can be found in the regulations. So very handy to go through there. Secondly, we would envisage sector codes for industry to be forthcoming within the next year or so, particularly looking at the healthcare industry. They have vast quantities of information, very, very sensitive information, and really to adopt a sector code under POPI would enable the healthcare industry to really adopt a bespoke code for the application of POPI in order to avoid particular breaches that are kind of industry tailor-made. Secondly, or second to lastly, rather, I would think that you'd have to take a really long and hard look at your so-called processor agreements or your third-party agreements, typically the agreements that are relating to cloud processing, to make sure that you have proper indemnities in place. It's absolutely essential. It cannot be stressed enough that as a responsible party, you will remain liable if you forward that information to a cloud processor. So really, you have to look at those agreements and make sure that they comply with the Act, firstly in terms of Section 20, and then secondly, making sure that you have proper indemnities in place. And then lastly, we would hope to see some guidelines from the regulator, particularly as to certain interpretational items in the Act. Ladies and gentlemen, that concludes my presentation for today, and I thank you for your time. I know I went slightly over. I have seen some questions coming in. We will look at those, and I will respond to them in due time. Thank you very much for your time, and enjoy your day.